Apple is suing a well-known YouTuber named what goes by the name of Front Page Tech, aka well known as John Prosser. And today I want to go deep down into this lawsuit, and I want to go read it out to you guys in today's video, and I want to go talk about why Apple is suing John Prosser for Apple leaks. So in case you don't know who John Prosser is, he is a YouTuber who owns the YouTube channel Front Page Tech. He does many iPhone leaks, which were actually from Apple themselves. Basically, how did he get this information? Well, not from China, but from actually directly from an Apple employee himself. And basically what happened was he yanked the, he basically contacted a mole, or a spy, sorry, and who basically had access to iOS 19, which is now known as iOS 26, and he was basically showing it off to John Prosser, and which was eventually used in John Prosser's concepts of iOS 19. John Prosser is a very well-known YouTuber, and honestly his leaks are pretty accurate, and what would you say, he got sued for this leak. I have never seen a tech YouTuber get sued by Apple. So yeah, and if it is, I haven't seen someone as this big as John Prosser. And yeah, I've watched him before. He's a very great YouTuber. He also does some other things other than iPhone leaks and stuff. And yeah, and the fact that I got the attention from Apple is very interesting. And yes, Apple does indeed watch these videos like on YouTube, but they also keep track of their employees. The mole was an Apple employee who works at Apple, which was Mr. Olympic or whatever heck his name was. You will find out in the lawsuit. And yeah, basically he was exposing trade secrets of Apple's unreleased products. Yeah, as I said, it's a bit complicated. Either way, John Prosser is now being sued for unveiling the unreleased OS, even though it's been already announced, which is pretty dumb. But I want to go over the lawsuit with you guys on my secondary phone, which is an S10 Plus. The reason why I can't do it on this phone is I cannot go through the web and record at once on my iPhone. All right, so as you can see here, one second, I'm just gonna try to sync this. So yeah, right now we're looking at the lawsuit from Apple. As you can see, this is from Scribd. Basically, this was linked in the Mac Rumors forum. So, sorry about that. Yeah, as you can see here, the defendant is Apple Incorporation, which, by the way, is Apple Inc., which is Tim Cook. And as you can see here, the defendant is John Prosser and Michael Ramcott, who was also a mole in this situation. And as you can see, we got the complaint. The complaints are misappropriation of trade secrets under Defend Trade Secrets of Act 18 USC 1836 and violation of the Computer Fraud and Abuse Act 1003. All right, so here we go. PanF Apple Inc., or PanF or Apple, is through an undesigned court counsel filed this complaint against defendants Michael Michael and John Prosser, collected defendants as alleged as follows. The case arises from defendants' coordinated scheme to break into Apple's development iPhone, steal Apple's trade secrets, and profit from theft. Defendants act harm Apple and its thousands of employees working tirelessly hard on iOS, iPadOS, who spend years working in secret on Apple's new features and products. Apple is a world-renowned technology company and a global leader in consumer electronics, mobile communication, and computing. With over 90,000 employees in the US alone, Apple invests billions of dollars on research and development within each year. Results of Apple's creative labors include Mac, iPhone, iPad, AirPods, Apple Watch, and Apple Vision Pro, as well as iOS and other software that powers the elements of those devices. So we're basically going on to talking about how our products are meant to be a secret and a surprise to many. This clip's going to be a bit long. I'm not even going to stop this clip because of how long it's going to be. All right, let's continue. Apple takes great care to protect the secrecy of its unreleased products and features. All employees are trained on protecting trade secrets and bound by conflicting secrets. Among other things, Apple also restricts access to buildings, devices, and files based on each employee's unassigned responsibilities. I can't speak today. I'm so sorry. But these safeguards can only go so far to protect against bad actors determined to steal Apple's trade secrets. The defendants here conspired to break into an Apple employee's development iPhone to take Apple's trade secrets on April 4th, 2025, which is before iOS 26, aka iOS 19, became a thing. Apple received an anonymous tip email about potential unauthorized disclosures of Apple's confidential information. Now, this has some actually censored names, so I will be just calling them blank, or John, for example. So here it is. So, as you see, the subject is iOS 19 leaker information, Ethan Lipink. I'm not sure who to contact, but the courtesy to the iOS 19 team at Apple, I wanted to share these information about an employee who leads the pre-released design details. The iOS 19 information shared by John Prosser and a source from Ethan Lipink. He shares 2 videos for iOS 19. There was a FaceTime call between Prosser and Lipink, and our friend Lipink's, where the iOS 19 interface was demonstrated to Prosser. Prosser has details on the lock screen, home screen, app animations, and app interfaces. The call is a few months ago. Prosser has video from it that shows the iOS 19 interface. Michael, blank, and blank are involved. Prosser also has been sharing clips from the recorded FaceTime call with Apple leakers. I am sure that Apple has the resources to further investigate. Blank has leaked iOS information to blank and others in the past. All right, let's continue. Apple's subsequent investigation revealed that the defendant John Prosser, working with defendant Michael, improperly accessed and disclosed Apple's highly confidential unreleased software designs, including details regarding to the unreleased iOS 19 operating system, which is now known as iOS 26, for Apple mobile devices. Both defendants knew that Apple goes to great lengths to protect its trade secrets information, including the highly sensitive information contained on devices that used to express the purpose of developing new products. The defendant also explicitly acknowledged that they were not authorized to access those devices, much less steal Apple's trade secrets from them. Defendant's misconduct was brazen and egregious. After Mr. Prosser learned that Mr. Rockwell needed money, and that his friend Ethan worked at Apple on unreleased software designs, defendants jointly planned to access Apple's confidential and trade secrets information from Mr. Lipink's Apple-owned development iPhone, obviously. Apple learned details of the scheme in Mr. Macaroni's own words through an audio message to Mr. Lipink, which Mr. Lipink provided to Apple. According to Mr. Macaroni's message, while staying at Mr. Lipink's home, Mr. Lacamoni used location tracking to determine when Mr. Lipink would be gone for an extended period, acquired his passcode, and broke into the development iPhone, which Mr. Lipink had failed to properly secure to Apple's policies. He detailed in an audio message, Mr. Macaroni made a video call to Mr. Processor and showed iOS on the development iPhone. He demonstrated several features and applications, disclosing details of the unreleased iOS 19 operating system. Mr. Macaroni admitted he knew this access and copying unauthorized and could put Mr. Lipink's career in jeopardy, but he did it anyway. Apple subsequently ended Mr. Lipink's employment for failing to follow Apple's policies designed to protect its confidential information, including development devices and unreleased software and features. Basically, they fired him. According to Mr. Lacamoni, Mr. Prosser proposed the scheme and promised to find a way for Mr. Lacamoni to get payment if Mr. Lacamoni would provide access to information. Mr. LePing's development iPhone, so Mr. Prosser can still profit from Apple's confidential information. Mr. Nakamoni acknowledged that Mr. Prosser recorded the video call with screen capture tools. Mr. Prosser took the videos of the trade secrets on the development iPhone, kept them from his own device, and dismissed and made those recordings to others. He shared recordings with at least one person who reported back to Mr. LePing that he recognized Mr. LePing's apartment in the recording. Ultimately, Mr. Prosser profited off Apple's trade secrets by at least sharing them in multiple videos in his business YouTube channel, which he generates an ad revenue, whatever you say. Defendants' unlawful acts, which can constitute knowing and intentional trade secrets misappropriation, have damaged Apple with respect to its competitors, including by giving them an advantage of knowing more about Apple's software designs and unreleased functionality in advance of their release. Moreover, Apple does not know the full extent of its trade secrets and confidential information that the defendants viewed or retained when they accessed Mr. LePing's development iPhone, which contained a significant amount of additional Apple trade secrets information that have not yet been publicly disclosed. In view of the audacity of their acquisition, and disclosure of its trade secrets, Apple fears that defendants will continue to misuse its trade secrets absent judicial intervention. So, here's 12. Apple therefore brings this lawsuit to protect its trade secrets and prevent Mr. Michael and Prosser from continuing to act unlawfully for damages arising from their misconduct. And yeah, it's actually pretty insane considering that, someone left their the Apple employee did a huge mistake, and I understand now why he got fired, and because he left the iPhone so another person can get the iPhone. This is almost as big as the iPhone 4 major leak. Yeah, you guys remember that? This court originally started over Apple's federal law claims under the Defend Trade Secrets Act and the Computer Fraud and Abuse and Federal Correction Jurisdiction under 26. Venue is proper under 28 because it's an essential part of the event or omissions giving rise to Apple's claims occurred in the jurisdictional district. Apple is a court. Mr. Rakamoni is a product analyst and video editor at NTFTW. Upon information and belief, he resides in Pioneer, California, is subject to both general and specific jurisdiction in California. Upon information in brief, Mr. Rakamoni's unauthorized access of the development iPhone took place at Mr. Pink's apartment in Santa Clara, California. Mr. Prosser has hosted the YouTube channel Front Page Tech since 2013. Upon information and belief, he resides in Denix City, Pennsylvania. This court has specific information on belief in as far as specific jurisdiction over Mr. Prosser. Anyway, it's getting boring now. I'm gonna stop the recording now. And yeah, basically what he's saying is that they had unauthorized access, and one second, I missed the part where they have to actually pay stuff. Yeah, they have to pay a huge fine and stuff for property damages, which is a bit fair. And yeah, as you can see here, we'll go down. Yeah, as you can see here, we're at the prayer for relief part now. Therefore, plaintiff pays Apple prays for judgment and relief against defendant as follows. A, judgment in Apple's favor and against defendants on all costs and alleged Heron, whatever you can say that, and judge of relief as court finds it necessary and appropriate damages and an amount trial punitive damages based on defendants' willful and malicious misappropriation of trade secrets in order from directing defendants not to make use or disclose Apple's confidential proprietary and trade secrets information to third parties without its written consent, and return to assist Apple in locating and destroying any such information of your possession, custody, or control. Sorry about that. Pre-judgment and post-judgment interest at the maximum legal rate is acceptable as an element of damages that Apple has suffered in a result of the defendant's wrongful and unlawful acts and recent attorneys' costs, fees and costs, and such other relief as the court deems just and proper. Apple demands a trial by jury for all causes of action, claims, or issues that the action are triable or as a matter of right to a jury. Basically, this lawsuit was created at July 17th, 2025, and yeah, you can basically tell that Apple is, to summarize, an Apple employee who is a mole is exposing Apple's trade secrets, which was the unreleased operating system iOS 19, which now is now known as iOS 26, and is accused of exposing Apple's trade secrets. So yeah, I gotta admit, it's a pretty huge hot lawsuit. I don't know who I hope to win, but it's a pretty huge lawsuit. That's all I can say.